Okay, we're good.
Good afternoon, everyone, where you are. Still morning where I am. I declare open this public hearing of the Joint Standing Committee on Treaties, and I acknowledge that we meet wherever we happen to be on land of First Nations people and pay respect to elders past, present, and emerging. That's the Whadjuk Noongar people where I am here in Fremantle, and of course the Ngunnawal and Ngambri people for those in Canberra, and other nations where members are dialling in from. These are public proceedings, and although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. In accordance with the committee's resolution of 4 August 2022, this hearing will be recorded and broadcast on the Parliament's website. The transcripts of proceedings will be published on the Parliament's website too. Those here today are advised that filming and recording are permitted during the hearing, and I remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. Transcripts of today's proceedings might not be available in time to meet the deadline that we set for questions on notice, so could I ask witnesses to please keep track of any questions that are put to you on notice so you're able to respond in the time required to ensure the committee can meet its reporting deadlines. We'll start today by taking evidence on the International Labour Organisation Convention concerning the elimination of violence and harassment in the world of work, and I welcome representatives from the Attorney General's Department, the Department of Employment and Workplace Relations, and the Department of Foreign Affairs and Trade to give evidence today. For the sake of the Hansard record, can I ask you to go along and state your full names and the capacities in which you appear before the committee?
Do you want to go first, Liz?
I'm Elizabeth De Hoog, Acting Assistant Secretary for the Safety and Compensation Policy Branch in the Department of Employment and Workplace Relations.
My name's Adrian Breen. I'm a Senior Executive Lawyer in the Workplace Relations Legal Division in the Department of Employment and Workplace Relations.
Sharon Hunda, Acting First Assistant Secretary, Employment Conditions Division, the Department of Employment and Workplace Relations.
Jennifer Weddinger, Assistant Secretary, Economics and International Labour Branch, Department of Employment and Workplace Relations.
Lani Rankin, Director of International Labour, Department of Employment and Workplace Relations.
Erin Murray, Director of the Respect at Work Task Force at the Attorney General's Department.
Kim Ralston, Department of Foreign Affairs and Trade, Director, International Law, Advising Human Rights and Treaties Section. Thank you.
Thanks to you all. The committee doesn't require you to give evidence under oath, but I advise you that this hearing is a legal proceeding for Parliament, therefore has the same standing as proceedings of the respective houses, which means the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make some opening statements or remarks before we proceed to committee discussion.
Thank you, Chair. We do have an opening statement. Thank you for the opportunity to appear before this committee to address the proposed ratification of the International Labour Organisation's Convention on Violence and Harassment, C190. The Convention is the first international instrument to specifically address violence and harassment in the world of work, an issue that affects the safety and wellbeing of thousands of Australians every year. The Convention calls on member states to prevent and eliminate all forms of violence and harassment in the world of work, including gender-based violence. It includes obligations to ensure the monitoring and enforcement of national laws and access to dispute resolution mechanisms, privacy and anti-discrimination obligations, and protection for people who may experience vulnerabilities. Australia's engagement at the ILO is done on a tripartite basis with the Australian Council of Trade Unions and the Australian Chamber of Commerce and Industry, both of whom support ratification of this convention. All states and territories also support the ratification of the convention. Ratification would confirm our commitment to the elimination and prevention of all forms of violence in the world of work. The ILO estimate that more than 1 in 5 people have experienced a form of violence and harassment in their working life. The Australian Human Rights Commission's National Survey in 2022 found in Australian workplaces, 1 in 3 had experienced sexual harassment in the previous 5 years. These numbers demonstrate both the magnitude of a problem and the need for an international agreement to recognise and respond to the right of all people to workplaces free from violence and harassment. Ratification of the Convention is a recommendation of a Respect at Work report, which the government is committed to implementing in full. While the Convention recognises the right to all to a workplace free of violence and harassment, it also acknowledges that gender-based violence and harassment disproportionately affects women and children. The economic empowerment and workforce participation of women is impacted by violence and harassment, including through the impacts of family and domestic violence. Ratification will contribute to the prevention of gender-based violence within the workplace and further supports Australia's commitment to advancing gender equality as a national and international priority. Australia took a leading role in the development of this landmark international agreement, demonstrating our commitment to eradicating workplace violence and harassment in the world of work. To date, 25 countries have ratified the Convention, and Australia stands to join these leaders in sending a message that violence and harassment at work is unacceptable, both within Australia and around the world. I turn now to Australia's compliance with the Convention. The combination of a range of Commonwealth, state and territory laws and policy provide a comprehensive framework to meet the obligations of the Convention. This includes strong workplace health and safety laws and policies to ensure all in the workplace take steps to prevent and address potential harms, anti-discrimination frameworks that protect people from sexual harassment and unfair treatment based on their sex, gender identity, sexual orientation, race, disability, age and other identifiers, a workplace relations framework that expressly prohibits sexual harassment and provides for paid family and domestic violence leave, and criminal laws that provide additional coverage and avenues for prosecution where appropriate and necessary. In addition, ratification of the Convention will support the full extension of a recently enacted paid family and domestic violence leave entitlement to all employees in Australia. To conclude, ratifying this convention would reconfirm Australia's ongoing commitment to prevent and eliminate workplace violence and harassment and advance gender equality both domestically and at the international level. Invite questions, Chair.
Thank you, and thanks for that opening statement. That was very helpful. I'll ask a couple of questions and then see if the Deputy Chair wants to follow me and other committee members. The ratification of the convention, which Australia had quite a role in helping to form, was recommendation 15 of the Jenkins report. I'd sort of invite you just to speak again. I know you touched on this a little bit in the opening statement, but in essence, what we're doing, the ratification follows from the Jenkins report, and there has been some recent reforms, some legislation to deliver those reforms that have sought to address the issue of violence and harassment in the workplace. And so, in effect, while the advice we're getting is that Australia complies with the convention, to some degree, the ratification itself and some of those legislative reforms have obviously responded to the fact that there was a view that we weren't as well placed to address or prevent those kinds of things until relatively recently. So I just invite you to touch upon the way in which the ratification follows from the Jenkins report and sits alongside some fairly recent reforms that also seek to improve the situation in the work world as far as Australia is concerned.
Thank you, Chair. And you are correct that recent developments have certainly strengthened Australia's compliance with the Convention. Our view was that we were already compliant, but certainly in the past 12 months in particular, significant further advancements have been made. I might actually cross to Ms Murray to talk about the sex discrimination elements.
Certainly. So In late 2020, the Second Respect at Work Act was made, and that implemented sort of the cornerstone reform of the Respect at Work report, which was the introduction of a positive duty on employers to prevent sexual harassment, sex discrimination and victimisation in the workplace. So this reform was implemented subsequent to us understanding our compliance with ILO 190, and certainly builds on the existing framework there, and recognises, the positive duty recognises the role that employers have and the way that they're uniquely placed to prevent sexual harassment in the workplace. So that was the key anti-discrimination reform in 2022.
There have also been a number of significant changes to the Fair Work Act in the past 18 months. In the Act that Ms Murray referred to, there was a change to introduce a stop sexual harassment order jurisdiction within the Fair Work Commission, and also some clarification that unfair dismissal could be you could summarily dismiss somebody for unfair dismissal if sexual harassment was involved. More recently, we've of course introduced a prohibition on sexual harassment into the Fair Work Act. That creates a new jurisdiction in the Fair Work Commission, which will allow people to bring disputes to the Fair Work Commission around harassment. So it gives them an alternative jurisdiction to the Australian Human Rights Commission, where they can join with other, if they've got other workplace disputes, and have those conciliated by the Fair Work Commission. That jurisdiction actually commences next Monday, so that's a positive piece there. We've also done some work in relation to work health and safety. Liz, did you want to talk about the...
Yeah, so in all jurisdictions, work health and safety laws do require persons conducting a business or undertaking to ensure the health and safety that's both physical and psychological to people within the workplace. The Respect at Work report included a recommendation to set out some more explicit regulations in work health and safety laws on that duty to ensure psychosocial risks are managed in the workplace. There was a number of other reports that have also made a similar recommendation. Subsequent to that, the national policy body Safe Work Australia, which maintains model work health and safety laws, has set out some and published regulations that provide more explicit detail around how duty holders should carry out that duty to manage psychosocial risks. Those were published in June, and now jurisdictions are in the process of implementing those regulations within their jurisdictional work health and safety laws.
Thank you. Yeah, I guess I'll pick up the point that was made before. Like it's interesting with a convention like this if the analysis was that we were in compliance in any case, but the ratification follows from the Jenkins report. The Jenkins report has a lot to say about this area and made some additional recommendations which are being picked up. I think members of the public would be interested to hear about the full value of a convention, particularly the forward value of it, if the analysis was that we actually didn't need to make some of the improvements we've just made in order to be in compliance, when those improvements seem to be are fairly important, and the data that we have on this issue, which is one of the points the Jenkins report makes, is that the data, our data position is probably not as we would want it to be, but to the extent that there was data that over the last 5 years, the period which you've just said we were already in compliance, suggests that 33% of Australians in the workforce experience sexual harassment. And if you look at a category like Aboriginal and Torres Strait Islander people, that rises to 56%. So I'm just... I assume that the view that we take of this convention is that it includes sort of additional obligations, or at least encouragement for Australia, the various governments, the Commonwealth and state territory governments, and the community at large to make further and better efforts. I mean, if we were in compliance when we had 1 in 3 Australians experience sexual harassment, that would suggest that the requirements of the convention should perhaps be more strenuous.
Thank you. I'll just add to what my colleagues have outlined in terms of some of the additional measures that the government's taken. I think your point's right in terms of the fact that we were already in compliance, but as you've stated, that the data has not been favourable. I think there's always more that can be done, and I think that what Australia's law and practice shows is that we're also not only wanting to meet the baseline obligations of the convention, but really wanting to strengthen and ensure that our compliance goes above and beyond. What I will say that the convention will do that's different to what's in existence, and one of the things that has happened since we did our initial law and practice assessment is the introduction of 10 days of paid family and domestic violence leave for employees at the National Employment Standards. That's under the National Employment Standards of the Fair Work Act. And what ratification will allow us to do is to extend coverage through use of the external affairs power, so that all employees will be able to have access and enjoy the benefits of the provisions there. So that's a really a strong reason for Australia to be ratifying. I think also it's important to note what this means for us on a number of levels. So domestically, it's absolutely very important for us to ratify the convention, but also internationally and within our region. So, for example, the convention builds on other UN conventions, such as the UN Convention on the Elimination of All Forms of Discrimination Against Women, and other ILO core conventions such as discrimination in employment and OH&S convention. And I think it also signals our commitment globally to eradicating violence and harassment. And we've seen the global campaign, the Me Too campaign and others. It's really showing that Australia is stepping up at that international level. Also internationally, I will note that achieving gender equality and empowering all women and girls is under the Sustainable Development Goals number 5. So it's showing that we're also trying to achieve those sustainable development goals and our commitment to that. Regionally, I would also note that within our region, the data is also not in our favour in terms of violence and harassment at work. And we're certainly seeing this through an ILO report, which shows that I think it was around a third of women and men in our region are experiencing violence and harassment at work. So it puts us in a position to showcase our credentials and also support our neighbouring countries to do better. And I would note that Fiji was one of the first of the 2 countries to ratify the convention, and we're really proud to say that that was with the assistance of some Australian support. We had a secondee in Fiji, so I think it's who sort of supported the Fijian government, I should say. So I think it's really important that on a number of levels we're showcasing our support, and I think going above and beyond the convention is only something that we can be proud of.
Thank you. I've got just a couple more questions. So if other committee members have questions, now is the time to indicate through the Secretariat. I'll come to you after that. So my final 2 questions. The first one goes to another observation of the Jenkins report, which was about the complexity of Commonwealth, state and territory legal and administrative arrangements that are in place to address violence and harassment in the world of work, noting that in some cases they're almost sort of parallel administrative opportunities, but as I understand it, in some cases people are essentially required to choose one or the other. Is that something that government has in view, and is there some intention to work to harmonise and streamline the frameworks and the administrative systems that are there that should obviously enable people who experience workplace violence or harassment to have those matters properly dealt with.
So in terms of the implementation of the Respect at Work report, a number of the recommendations went to this interplay between different governments and different regimes. One of the big things that we did was the establishment of the Respect at Work Council, which includes representatives on behalf of all the state and territory work health safety regulators and all the state and territory human rights commissions. So they all come together as part of that group to sort of look at the interplay between the frameworks and how reforms operate in that space. There were a number of recommendations, off the top of my head, I think it's 26 and 39, which specifically went to interactions and consistency between jurisdictions. So recommendation 26 is focused on consistency and, where appropriate, alignment between jurisdictions when we talk about human rights protection, so sex discrimination and sexual harassment, and jurisdictions are actively working on alignment in areas of focus through the Standing Council of Attorneys General at the moment. So that is something that is front of mind, and we do have a number of existing bodies that bring our different levels of government with interest in the same space together, and I think Respect at Work, particularly through the council, has really sought to bring those minds together to make sure that people have consistent rights protection and access to resolution for issues in this space.
Thank you. My last question just goes to the way in which the Convention sensibly contemplates the range of ways in which people are engaged in work and the fact that that's a developing space, and we talk about the gig economy and the kind of work that involves. So I just invite you to say something about how Australia has any specific measures or means through which people involved in informal work or the gig economy can raise issues of violence and harassment. And one of the things I note in the Convention is the specific obligation in Part 4 that talks about the vital role of public authorities in the case of informal economy workers, and whether, in your view, those public authorities already exist, and if so, who they are, and if they don't, what kind of public, perhaps a dedicated type of public authority might be required to properly support people in the informal economy as contemplated and indeed required by the Convention.
Thanks, Chair. So just in relation to obviously that important emerging area of, as you say, gig workers and the broader informal economy, and as in terms of the evidence, consistent with the evidence has been provided already, Australia's compliance with C190 depends on, I guess, a range of platforms, whether it's the Fair Work Act, whether it's work health safety laws, criminal laws, anti-discrimination laws in both the federal and state and territory jurisdictions. I think it's important to note that irrespective of whether, for example, the Fair Work Act protections apply to gig workers or what we might refer to as workers in the informal economy, that'll often come down to a question, I guess a legal question, dependent on the facts. So there's a question mark there, but the broader coverage of the work health safety laws, which don't depend on the existence of an employment relationship, the language used in work health safety laws is that of worker. And so I think it's certainly clear that those in the gig economy will generally be afforded protections in that way, whether or not they're seen to be employees. So that broader amount of coverage from the work health safety laws does provide that important coverage. And in terms of the informal economy, I guess that's often comes down to a question of definition in terms of I guess, may mean economic activities not covered or insufficiently covered by formal arrangements. But we have there, to the extent that workers aren't covered by formal arrangements in Australia, they are afforded protection from violence and harassment. I guess in the course of public life, we would say at the federal, state and territory level, there's protections there under criminal law, again, as I mentioned, anti-discrimination, work health safety and fair work authorities, which incidentally cover informal workers. So I suppose that's the broad answer. Is there anything specific you'd like to look at more closely, Chair?
Well, I mean, it's a good answer, but unless I'm hearing it wrong, you're essentially saying that that there's a range of protections against something like violence that just exist for the benefit of any Australian citizen or resident. So to some degree, everyone is protected by those. And if you happen to be working in the gig economy and you experience violence by another individual, you could seek remedies by calling the police. I mean, it seems that the part of what this convention is doing, which is novel, is, well, first of all, having a specific definition within it of what constitutes violence and harassment in the working environment, but then contemplating how those circumstances and the relationships in the world of work are productive of instances of violence and harassment. It's not, we don't say that we're looking at this area particularly because violence and harassment just happens to occur in the world of work as it might happen in the world of sport or the world of bushwalking or something. I mean, it's the nature of the relationship, the power imbalance that often exists between employers and employees that gives rise to the potential for violence and harassment. That's why we need to have a particular way of looking at it. We know that the gig economy and informal work is a growing part of the work world, and the convention seems to recognise that. So I guess my question at the outset was around this issue of public authorities. Have we got in mind the development of something that is specific to the informal economy? Or is the view currently, as you sort of described, that there's a patchwork of bits and pieces that people in the informal economy have access to and for the time being need to make the best of?
So thanks, Chair. And I should be clearer. In terms of that patchwork, we would say that there's a primary role for the work health safety laws in relation to gig workers. So irrespective of whether those workers are seen to be employees, the work health safety framework clearly provides protections for all workers. And so generally speaking, you would expect, or we would expect, that gig workers would fall within the definition of worker and be protected by the model work health safety laws, which have been implemented in most jurisdictions. And so then there would be there is a role for work health safety regulators in each of those jurisdictions in relation to those gig workers. So I was probably not as clear as I might have been in terms of those protections which currently exist for gig workers in the work health safety context.
Chair, I'd also add that the government's committed to giving the Fair Work Commission the power to set minimum standards for employee-like workers. We're currently consulting on that particular measure. It's something that I think the Minister said at a recent National Press Club address he would like to legislate later this year, and that's certainly one of the things that we're looking at in terms of what sort of minimum standards they should be.
Thank you. That's very helpful. Just for the interest of the committee, we've been pointed to two sources of data: the ABS Personal Safety Australia report and the AHRC's Time for Respect piece of work. I know you're not responsible for those pieces of work, but have they in the last several years provided data that is specific to the informal economy?
Specific to the informal economy, sorry, Chair.
Sorry, the informal economy.
Unfortunately, ABS, because in Australia the informal economy is so small, it's very hard for the ABS to calculate that. So they don't calculate the informal economy. If you're talking about the gig economy, which is not part of the informal economy, that's a different question. But the informal economy is not in a country like Australia. It's not actually measured.
And the gig economy?
The gig economy, there's the ABS are currently in a process of data collection for the gig economy. There are a number of informal sources, or I guess not as authoritative as the Australian Bureau of Statistics. There's, for example, one figure that I know of around 250,000, but the gig economy is part of the broader independent contractor cohort, which is currently sitting at around 8.8%. Of employees, of all employees. So we estimate that the gig economy is around sort of 1 to 3%. But there is no authoritative data at this stage on the gig economy, but it is developing, and it's something the ABS are working on.
Okay, thank you. Look, I appreciate it. I'm not sure if anyone else has questions they should indicate now. This is your last opportunity, but so far I haven't had those indications. So on that basis, I will thank all of you for your attendance in Canberra today. You haven't been asked to provide any additional information that I can remember, but if I'm remiss on that and you have, it needs to be forwarded to the Secretary by the close of business this Wednesday, the 1st of March. And as I said in my opening remarks, that's the responsibility of witnesses attending the hearing. Otherwise, you will of course be sent a copy of the transcript of your evidence when it becomes available, and have an opportunity to request corrections to transcription errors. But again, thank you all for your work and for your attendance at the hearing today. So committee members, we're just going to suspend briefly while Secretariat sees if they can get our next witness to come forward a little bit. So we'll just suspend for the time being. And welcome Professor Sean Cooney to give evidence today. For the Hansard record, could you please state your full name and the capacity in which you appear before us today?
Yes, thank you. My name is Professor Sean Cooney, and I'm a professor at Melbourne University Law School at the University of Melbourne. And I'm my main research area is international comparative labour and employment law, and I was also an ILO, an official of the International Labour Organisation between 2014 and 2016. But I'm giving these comments in my own capacity.
Thank you, Professor Cooney. The committee doesn't require you to give your evidence today under oath, but I advise you that it's nevertheless a hearing. This hearing is a legal proceeding of Parliament, therefore has the same standing as the proceeding of the respective houses, means that giving false or misleading evidence is a serious matter and may be regarded by Parliament. The evidence you give today will be recorded by Hansard and attracts parliamentary privilege. So thank you for the submission that you've made. I now invite you to make some opening remarks or give us a brief opening statement before we proceed to discussion.
Thank you very much, and thank you to the Chair and also to the other committee members for giving me the opportunity to address you on the ILO's Convention concerning elimination of violence and harassment in the world of work. I'd really like to make two key points. One is that the ratification of this convention will assist this country in our efforts to eliminate violence and harassment in all its forms with respect to everyone who engages in work. And the second is that Australia's ratification will provide an important example to countries in our region that are also considering ratifying this convention. So I'll just develop those 2 points very briefly. On the first point, Australia has one of the best health and safety frameworks in the world. And I say that as someone that, when I worked in the International Labour Organisation, dealt with many different jurisdictions. It's also made very significant recent advances in relation to harassment, including gender-based harassment. So ratifying the treaty would not entail making major legislative reforms, but it would prompt Australia to make sure there are no gaps in protection and would, of course, provide a constitutional basis for the Commonwealth to address any shortcomings. This is because the Convention is comprehensive and covers all aspects of the world of work and endeavours to prevent violence and harassment in every possible configuration of a workplace. So member states under it are required to have an inclusive, integrated and gender responsive approach for the prevention and elimination of violence and harassment. The Convention aims, as I say, to protect workers and other persons in the world of work. And it's not just employees, but interns and apprentices and volunteers and job seekers and business operators. All of these people can be subject to violence and harassment. And the particular contractual arrangements or business structures are irrelevant to the coverage of this convention. And that's different from in the past when perhaps only employees were protected. The Convention also applies to many different kinds of workplaces, not just traditional physical spaces, but digital work, work-related facilities and social events, and trips and training events. Ratification of the Convention provides Australia with an opportunity to track its progress in preventing violence and harassment in all these different sorts of combinations and settings. The second point I want to raise is that in ratifying the Convention, Australia can encourage other countries to do the same. The Convention was adopted by the overwhelming number of member states at the ILO and has been ratified in many significant jurisdictions, including the United Kingdom, Canada, South Africa, Italy, Argentina and Ireland. But so far, it's not been ratified by many Asia-Pacific states. I think Fiji, last time I looked, which was this morning, is the only state in our region that has ratified the Convention. But other nations are considering it. I'm working on a project at the moment in Pakistan, and I know Pakistan is considering ratification. So it will be good to provide a regional example for domestic voices in many countries that support the reform. So I thank again the committee for its time and stand ready to address any questions that the committee may have.
Thanks, Professor Cooney, and I'll kick us off and go around to other committee members to the extent that people have questions. I just start by acknowledging the contribution that you personally have made to this area of life and regulation. Obviously, it's consideration in Australia, but also our participation in multilateral processes, global processes that lead to important agreements like this one, which we are considering ratification of. I guess I'd invite you just to start off. I mean, we heard the departmental people before say something similar to what you mentioned, which is that Australia's regulatory framework actually is a pretty good one. At the same time, if you look at the Time for Respect survey, the incidence of violence and harassment in the workplace is pretty horrifying. If it's 33% of Australians experience sexual harassment, 1 in 3 experience sexual harassment in the workplace, and then when you look at some sections of the community, Aboriginal and Torres Strait Islander people, 56%, people identifying as having a disability, 48%. That's horrible to contemplate. Perhaps you just start by taking us back to first principles and talking about why it is that the world of work is a set of relations and a kind of a place of certain kinds of activities and conduct that make harassment and violence, well, they're prevalent clearly, but it's susceptible to those kinds of behaviour.
Yes, so I think perhaps the best way to approach this is to think back in some of the international meetings that I was a bit involved in back in 2015, 2016, when this convention was being put together. And those sorts of statistics were presented, and it's not just characteristic of Australia, but many, many jurisdictions around the world. And the sorts of stories that were being told there were for example, a situation where someone's client-facing, and we know that in terms of the delivery of services, many individuals become highly stressed and frustrated. And so people such as medical staff, doctors and nurses, can confront those very agitated people and be at the receiving end of violence. And there were stories about that all over the world. So this is the kind of interaction between people with public-facing jobs. And those people under a lot of pressure. Of course, at workplaces themselves, we know that unfortunately, some co-workers, some employers, and so forth can subject other people to violence and so forth, and harassment. I work at a university, a long-standing university, which unfortunately has uncovered, a significant number of cases. So even within the workplace, these sorts of issues are, as you've pointed out, distressingly prevalent. And we could sort of go on talking about what happened during the pandemic, because some of these sorts of behaviours were exacerbated. I've participated in an international study recently comparing about 10 jurisdictions. Again, it's run by the ILO, looking at frontline workers again. And I mentioned before health workers, and you'd think they'd be the people that were most subject to violence and by agitated people, but often it was people working in supermarkets, people who are transport workers and delivering things that were subject to violence, again through agitated people, particularly during the pandemic. So there's a whole range of situations in which violence can occur, and that's why this convention is very comprehensive. It's trying to capture those myriad ways in which people can encounter these terrible situations.
As in many areas of life, I think particularly for people in our role, parliamentarians that are sort of lawmakers, it can be a tendency to look at an issue or problem and think about how you deal with it from a regulatory point of view. So how you see it and capture it and allow people to report it, and then hold people responsible for behaviour that's not acceptable or is unlawful or criminal. But clearly, in many instances, when we want to see substantial change, it's actually about sort of normative change. It's about getting to the point where those kinds of behaviours don't occur because we change culturally. Is there a role? Does the convention have a role in encouraging that kind of work? And is that something that you think Australia is undertaking?
Yes, it very much does. And a lot of this convention is directed at educational processes and so on, and to get people to change norms. It's not purely a punitive legal instrument. I'm looking at Chapter 2, which is about protection and prevention. One thing to point out about this convention that makes it particularly interesting is it's trying to bring together two different things that in many countries, including Australia, have historically been kept separate. And I think one of those is work safety, occupational health and safety. We prefer to say work health and safety in Australia, and equality law or anti-discrimination law. And they've operated separately with different sorts of logics. And of those two, the more successful, at least in Australian terms, is work health and safety law. It's got really, as I said before, I think we've got one of the most developed frameworks in the world that I've encountered, been adopted by other places, New Zealand, Singapore, and so forth. And that has very extensive preventative measures that are based in workplaces that involve consultation and so on. And our framework is adapted to very complex workplaces, not just traditional employer-employee arrangements. And if we can, and I think Australia has done this, increasingly include questions of violence and harassment within that framework that was originally used to stop sort of dangerous workplace equipment. That was the origin in the Factory Acts and so on. If we can apply that sort of framework to these broader questions of violence and harassment, then I think there is a lot of opportunity to change norms in workplaces, to be preventative, not just to punish people that have engaged in appropriate conduct. And I think Australia is very well placed in that regard. I think we're just at the beginning of exploring how work safety can be used. I know the various regulatory authorities around Australia are starting to add specifically sexual harassment and so on. But we're really only at the beginning of that happening.
All right, my last question to you before I invite other committee members to jump in is around this. As a part of your submission that talks about the Australia's further implementation of measures in the convention. Now, the advice we have is that, strictly speaking, we are in compliance, but clearly, off the back of the Jenkins report, some of the recent legislative reforms, Australia doesn't take the view that that's the end. We recognise that there's significant further work to be done, guided by and in the spirit of the convention, both in traditional areas of the world of work and in emerging areas of like the gig economy. When you talk about sort of the further implementation of the measures in the convention, perhaps you just outline a couple of the things that you think ought to we ought to be looking at in the sort of the short term.
Yes. So with the question, what are the longer term measures, or what are the shorter term measures in terms of compliance or
either, frankly, but really just the things that are ahead of us. I mean, notwithstanding the idea that we're in compliance, you might just say from a strict treaty compliance point of view that we could we could close our book and move on. Clearly, that's not the case, and those statistics I cited before indicate that by having a good framework, there is a lot of progress to be made. I'm just interested in what kinds of things you think ought to be progressed.
Yeah, thank you. I mean, an obvious area is the gig economy, because we're only now starting to sort through really difficult questions of who's responsible for what. To what extent are the digital labour platforms responsible for implementing measures to eliminate, reduce the risk of violence and harassment for delivery drivers or people that sit at home and do work coming from all around the world. I mean, there's many situations that no one around the world has got a full answer for. And so some of the challenges, I think, will be around digital work at home, around the gig economy and so forth, as well as improving processes within traditional workplaces and making them, as I said, perhaps using work safety and exploring how that could be used in the hospital setting a bit more to protect, say, nurses and doctors and supporting staff and patients. So there are just three different areas that I've pointed to then, and they're by no means exhaustive.
Thank you. That's helpful. I've got a question from Mr. Pike.
Thank you, Chair. Just a quick one, Professor Cooney. You mentioned that in our region we haven't had a great level of adoption of this convention yet. I was just wondering whether, obviously, given your insights on the international scene, has there been any stated or any nations that are outlining an objection, or are they simply haven't gotten around to it yet? Just interested to know if there's any countries that are particularly taking exception to anything that's contained in here.
No, as far as I know, the only country that seems to have had objected at the time of the treaty the convention was adopted, which is back in 2019, was Malaysia, and I don't know why that happened. Obviously, there's been several changes of government in Malaysia over the last few years, and I don't know whether they maintain that position, but all other countries in the region, as far as I can recall, were supportive. I mean, that doesn't mean that, as you probably know, the ILO delegations, national delegations, consist not only of government representatives but of worker representatives and employer representatives. So when I say that all other countries supported, there may have been an employer representative or a union representative that objected for some reason, but essentially all member states, with the exception of Malaysia, supported this convention. So I take it as being more a case of they haven't got around to it than they object. But can I say something that may contribute to this, and that derives from a work I've done in a lot of countries around our region. The capacity, even of very large states, to implement some of these measures is limited. And the more that you have examples of where another country, particularly one that's in the region, has been able to give effect to these conventions, the easier it is for those within a place like Pakistan, where I'm working at the moment, to see, oh, that's how you would implement it. Oh, I see. This is what we can do here. So that's why I think Australia is very important. People do, especially in our region, watch what we do. No one should copy our laws. Sort of without qualification, of course, they have to be adapted to national conditions, but they can give some indication of how you, in practice, create and improve working environments, legislation pertaining to those education campaigns and so on. Because, as I say, many of the people charged with implementing work health and safety or equality in other places are under-resourced. They don't know how to draft legislation. Sometimes they don't know how to set up agencies. They don't know how to facilitate dialogue between employers and workers and so forth. And they will look to places like Australia, and they do look to places like Australia in that regard.
Thanks, Chair.
Yeah.
Thank you, Mr. Pike. I've got a question from Mr. Burnell.
Thank you, Chair. Thank you for coming in and giving evidence today, Professor Mooney. My question's just in relation to your statement around our ability to help influence the uptake in our region. What does that look like in your view, apart from what you briefly outlined from the previous committee member? But I'm interested to get a better understanding of what you see as our ability to influence a shift in sentiment in other workplaces from our foreign neighbours.
Yeah, so perhaps I can answer that question just by giving some examples from my own direct experience. So in the last, since I came back to the university from the International Labour Organisation, I've been involved in law reforms to India, to Vietnam and to Pakistan most recently. I mentioned that. And some of those, and I've also continued some engagements with other places like China. It's a bit more difficult than it was. And what often people will, what you're dealing with is a government department, and they will be confronted with something like this and they'll not know what to do. Surprisingly, many countries in our region, perhaps even large ones, have laws that are quite antiquated. So in the case of, I think people will be, the countries concerned will be too upset saying this, but many of the, say the former British colonies still retain laws that go back to colonial times. And if we're dealing with the gig economy or digital work, those laws are manifestly inadequate. So places like Pakistan or India will look to Australia as another common law system with a similar legal tradition, and see how we've been able to amend those laws, to change them, and to create sort of innovations. So that's one example. But even in a place like Vietnam, which has obviously a very different political system and a different a different legal framework, they'll still look to Australia as an advanced economy in the area with which they have very significant connection, and ask questions about, well, how do you deal with these sorts of issues? I found, particularly in Vietnam, a very high degree of sort of curiosity and interest, despite the difficult political environment there, in learning from other countries and trying to develop new laws that suit the sorts of society that they're at. And some things they've done have been fairly impressive. So they're just three instances, and I state those because they're the three I've worked with most recently. The current project in Pakistan, for example, where they have devolved employment laws that devolved to the provincial level. So we're working with Punjab and Sindh, the two largest provinces, on a complete overhaul of their framework. And we are, and as I mentioned, Pakistan is interested in ratifying this convention. So it's really good going into conversations and saying, you need to do something that suits Pakistan. But here's what happened in Australia, and here, Australia's not perfect, but here's examples of laws that really take the country pretty close to what this convention wants. And that's a really useful conversation to have, where people are not sure what this means. And maybe, some people that work in these departments don't have a background in law, don't have a background in employment relations. They may even be statisticians, and to give them practical examples can be extremely useful. I'm certainly not saying they always adopt them, but they're quite useful, and I think as a nation we shouldn't underestimate the impact that we can have in regionally, but even internationally. Because I get asked, and my colleagues get asked all the time from Geneva, "Can you tell us what Australia is doing in this space?" Often it's a good story here.
Thank you very much for that. Appreciate your answer.
Thank you. Thank you, Mr. Burnell. I don't believe we have questions from other committee members, so I will thank you again, Professor Cooney, for your attendance today. We haven't asked you to provide any additional information. You will be sent a copy of the transcript of your evidence when it becomes available, and then have an opportunity to request corrections to transcription errors. But again, thanks for the work that you did in the lead up to this, and for your submission and your time with us today.
Oh, thank you very much for giving me the opportunity to speak to you. It's much appreciated. Okay.
So I think, committee members, we are able to move on to our next attendee. Fiona will tell me that that's true. Can't hear Fiona. I'm going to welcome Lisa Heap to give evidence today at this public hearing of the Joint Standing Committee on Treaties. For the Hansard record, would you please state your full name and the capacity in which you appear before us?
Thank you, Chair. My name is Lisa Suzanne Heap, and I appear on my own behalf today, but I am also talking to you about my doctoral research, which I'm completing at RMIT University.
Excellent, thank you. The committee doesn't require you to give your evidence today under oath, but I should advise you that this hearing is a legal proceeding. The Parliament therefore has the same standing as the proceedings of the respective houses, which means that the giving of false or misleading evidence is a serious matter that might be regarded, or may be regarded, as a contempt of Parliament. The evidence you give to us will be recorded by Hansard and attracts parliamentary privilege. I thank you for the submission that you've made. I invite you to make some opening remarks before we proceed to a discussion and some questions.
Thank you for that opportunity. And thank you for the opportunity to make a submission to your inquiry and to appear before you today. And in doing so, I'd like to recognise the traditional custodians on the lands on which I am presenting to you from today, the Boonwurrung people in the inner western area of Melbourne, and pay my respects to elders past, present and emerging. In my written submission, I set out what I believe are some key benefits and opportunities associated with Australia ratifying and implementing this convention and its accompanying recommendation. My submission is drawn from my current doctoral research, which is examining the potential of new regulatory approaches beyond the predominant anti-discrimination approach to prevent gender-based violence and harassment in the world of work. And in this research, I examine in detail the provisions of the Convention and the recommendation and the concepts and principles which underpin their content. In addition to my research, my opinion is also informed by my participation as a member of the ILO Standards Setting Committee for the making of ILO C190 in 2018 and 2019 in my capacity as a technical advisor for the Australian Workers Representative. My experience is also as a labour lawyer and union official for over 30 years, during which time in particular during 2015 and 2018, I led the Victorian Union Movement's initiative to address gender-based violence and harassment as a work health and safety concern. So very briefly, I would like to highlight the following 4 areas of the Convention and its accompanying recommendation, which I believe could assist in developing more effective regulatory approaches designed to eliminate and prevent violence and harassment in the world of work in Australia. First, the representation of violence and harassment as a complex, multi-layered problem breaks with historical framing of violence and harassment as an individual issue and one of interpersonal conflict. C190 therefore calls on solutions to this problem which contemplate not only the behavioural and the cultural aspects of violence and harassment, but also the institutional and the structural. In this way, the Convention requires approaches that address how the conditions of work, including how work is organised, the gender segregation of work and the labour market, insecurity and precarity at work, creates the conditions of violence and harassment. 2, the Convention comprehends violence and harassment as a gendered phenomenon that women and girls disproportionately experience and are impacted by violence and harassment both inside and outside of work is acknowledged and is incorporated into the core of the provisions and the overall approach taken in the Convention. Therefore, there is a need to tackle underlying causal mechanisms and risk factors that create the conditions of gender-based violence and harassment, including gender-based stereotypes, multiple and intersecting forms of discrimination, and unequal gender-based power relationships in order to end violence and harassment in the world of work. 3, the inclusiveness is an important aspect of the Convention. The Convention seeks to be inclusive of both all forms of violence and harassment and all persons in the world of work. The concept of inclusiveness contained within the Convention starts with the right of everyone to a world of work free of violence and harassment and extends to ensure that the scope of rights and protections contained within it are broad. There is a universal right to be free from violence and harassment in the world of work. An important principle is that no worker is left behind, including those in vulnerable and insecure forms of employment. There is a broad definition of violence and harassment, including gender-based violence, and an expansive view of the circumstances, locations and sectors within the labour market that constitute the world of work. And 4th, the call for an integrated approach to addressing violence and harassment contained in the Convention is in a response to the gaps in regulatory approaches and the impact of siloed policy approaches that had been identified by the ILO. An integrated approach to social policy involves matching policy goals and means through mixing up and changing historical policy regimes which have been siloed from one another. We've seen this siloing in Australia through the historical separation of discrimination and equality rights approaches from the more traditional forms of regulation at work through workplace rights and workplace health and safety regulation. In my opinion, therefore, the Convention and its accompanying recommendations have a lot to offer as a framework for new regulatory approaches to violence and harassment in the world of work, and I therefore recommend that Australia ratifies these instruments and that relevant bodies review regulation, policy and practice to ensure alignment with the conceptual framework, the principles underpinning the provisions and the specific provisions contained within those instruments. Thank you.
Thank you. That's really helpful, and for your submission, which obviously springs from a considerable contribution involvement in this area, directly, well, convention related and more broadly over a period of time. I've got a few questions, and then I'll ask the deputy chair or others to jump in. Perhaps for the interest of the committee and anyone else who's listening in, perhaps you could give us a sense in as practical way as possible of the sort of shortcomings of an anti-discrimination approach as compared to an approach that encompasses other means of tackling this problem.
Thank you so much for that opportunity, which is a major theme within my research. I mean, the difficulty we have with the anti-discrimination approach, as we have taken in Australia, is that it's invested in individuals addressing the concern and individuals who are victims of violence and harassment bringing forward their complaint. And having that addressed through a system which is quite a hostile environment. So that individualistic characterisation of the issue works both in terms of seeing the victim as an individual in isolation from other circumstances, but also the perpetrator as an individual. And we've almost sort of taken up this view of particularly gender-based violence in the form of sexual harassment in Australia as one that's perpetuated by individual aberrant people who are doing a bad thing, and that they're the problem. If you remove those from the workplace, then that will be the end of the problem. And, you know, what we know now, and that was kind of interesting when the Sex Discrimination Act came into being, but we now need to have a much more holistic view of violence and harassment. And in particular, we need to have a look at how the conditions of work set up the structural power dynamics in the workplace that reinforce and also create the conditions for violence. So, for example, in relation to gender-based violence, we need to have mechanisms that look more at how the gender segregation of work, how that women are in particular parts of the workplace which give them greater exposure to violence and harassment, how things like setting up arrangements around people going into people's homes to care for others, how that creates conditions for violence and harassment, not just the fact that there might be individuals who perpetuate violence and harassment.
Yeah, that's helpful. I'm also mindful that, and we've heard from other people in the course of this hearing about the fact that it goes a little bit to what you were just saying, that if we really want to see an end to what unfortunately is very prevalent, even in a place like Australia, the sort of the post facto regulatory type of thing where something happens and then you identify it and respond to it and make somebody responsible and give another person support. That has to be part of the approach, but in many ways, and we've seen this in other areas of life, the best thing to achieve goes to what you're talking about, which is normative change and structural change. That means that those behaviours just don't occur. You talk about a comprehensive strategy at paragraph 21. I just invite you to make some observations about that, the kinds of things that would form part of a comprehensive prevention strategy.
Yes, thank you for that opportunity. First of all, in terms of addressing a comprehensive strategy, I think we have to have a comprehensive definition of violence and harassment. I mean, currently, at the moment, potentially rightfully, given the statistics, there's a focus on sexual harassment in the workplace, but violence and harassment at work is broader than that, and even the violence and harassment that women experience in the workplace is broader than sexual harassment. So we need frameworks that are broad in terms of definition of violence and harassment. We need an understanding of violence and harassment as a means of social control, not just as an the outcome of the actions of a few aberrant individuals. We need to have an understanding of the world of work, and that's one of the breakthrough things that the convention does, which is comprehend that regardless of where you are in the labour market, where you are in rural locations or urban locations, everyone should be free from violence and harassment at work, and therefore that sort of broad comprehension of all of the circumstances of work is an important thing. We need to have a focus that, as you pointed out, I think, Chair, that focuses on prevention rather than response, or that focuses on prevention and response probably, and has that idea of primary prevention, preventing it before it starts, and then also responding more effectively when it has occurred. The idea of no worker left behind means, under the convention, means that there is particular attention given to particularly vulnerable groups, and that includes people in informal work, people in less secure forms of employment, which need specific attention and real action to address those things, other than just saying, well, we'll make something globally that applies and people can try and access those rights if they have the capacity to do it. And we really need two more things, I think. One is regulators need the resources and the capacity to deal with this phenomenon in more detail. Too frequently, I think our regulators are under-resourced for the issue and also kind of stuck in traditional ways of approaching the problem, and they need to be shaken out of those ways. And we need to have the idea of a regulating community. So particularly from my point of view, we need to have a really valid role for trade unions in this process, because they are out in workplaces, and we need to have, them having standing to be able to bring forward on behalf of individuals who can't bring forward concerns themselves, standing to do that.
Thank you. I appreciate that. My final question before I go to other committee members just goes to the point you make about in the convention. Obviously, there's a commitment to a gender responsive approach, and we know from all of the data that that's important. If you look at, women and girls are badly overrepresented as far as people who experience violence and harassment, and including sexual violence at work. But if you look at groups that are also overrepresented, Aboriginal, Torres Strait Islander people, then within that, women and girls within the ATSI cohort, again with disability, women and girls within the disability cohort. But you talk about not just a gender responsive approach, but a gender transformative approach. So my final question to you is, if you'd just like to explain why you feel that's important and what that distinction really means.
Thank you, Chair. I suppose the convention actually has a gender responsive approach, and so I'm asking people to go beyond the convention in their thinking. And the gender responsive approach is on a spectrum. If you go from gender blind at one end of the spectrum to gender transformative at another. So gender blind approaches are ones that just treat everyone the same and presume that if you have an initiative that's you can frame it that way, and it doesn't affect anyone differently. And that's the traditional way of dealing with the fact that the work is described really framed around men's experience of work. And if you have a gender blind approach, then you don't take in at all women's experience. A gender sensitive approach means that you're aware of the fact that gender makes a difference in the workplace, but you're aware of it, but you don't necessarily do much about it. A gender responsive approach is putting more obligation on, saying, well, no, it's not enough to be aware of it. You actually have to take specific affirmative actions to address inequality, particularly gender inequality at work. A gender transformative approach, which is what I'm promoting, is really saying, actually, we've got a lot of work to do to unpack how we see work, who we see as a worker, how work is organised, around men's experience of work. We've got a lot of work to do, and part of that is transforming the gender relationships that exist at work. So that's about sort of really unpacking everything we do in the world of work and seeing it differently, which means it will work more effectively for both men and women, because there are a lot of men who don't fit into the dominant hegemonic view about the male worker as well. So yeah, that's the gender transformative approach. And you know, my concern is a little bit in relation to, I mean, I understand that that Australia has a view, and I think that's right, that it's compliant with the provisions of C190 and therefore can go forward to ratification. I think it is in terms of their compliance, but there's a lot to do in those framings, a lot more work that we could be doing to advance our understandings and to really take a leading role after ratifying the convention and the recommendation.
Thank you. That's well said. I haven't got an indication of other questions from committee members. So I will thank you for your attendance here today, the submission you've made and the evidence you've given. We haven't asked you to provide any additional information, but you will be sent a copy of the transcript of the evidence you've just given when it becomes available, hopefully in the next few days, and you will then have an opportunity to request corrections to any transcription errors. But again, thanks for your involvement, your evidence here today, and as you've indicated, your ongoing work in this area.
Thank you very much for the opportunity. Thank you.
Committee members, unless Fiona advises me otherwise, we now need to suspend because the Australian Human Rights Commission and Commissioner Jenkins is not available until 3:30 Australian Eastern Standard Time. Is that correct, Fiona?
That's right, Chair.
Okay. So on that basis, I will suspend and look forward to seeing you all in 23 minutes. Thank you. Committee members, we will now resume the Joint Standing Committee on Treaties hearing into the International Labour Organisation Convention concerning the elimination of violence and harassment in the world of work. And I welcome Commissioner Kate Jenkins to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee today?
Yes, I'm Kate Michelle Jenkins and I'm the Australian Sex Discrimination Commissioner.
Thank you. The committee doesn't require you to give evidence under oath, but I advise you that hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses, which means the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So we thank you for your submission and your appearance before us today, and I invite you to make some opening remarks before we proceed to questions and discussion.
Thank you, Chair, and thank you to the committee for welcoming me. I've just got a couple of remarks to make before I welcome any questions. Firstly, I would like to recognise the leadership that Australia has already shown in the adoption of the Convention, ILO 190, the Convention concerning the elimination of violence and harassment in the world of work, which occurred in June 2019. Just for some context, I know some of the questions have been around how respect at work intersects with this convention. So I thought it worth mentioning that in July 2018, just after the Sexual Harassment National Inquiry had been announced, I was in Geneva for Australia's last report back to the CEDAW committee, and I met with the Assistant Director General Manuel Tomei at that point in time to discuss the work that they had already done towards this convention. So that was a good 12 months before it occurred. And as a result, well, sort of entirely connected to our national inquiry, we drew on the work that had already been done, of which Australia had been an active participant in some of the lessons about violence and harassment in the world of work. So it is not a complete coincidence. Certainly, we came up with a strong recommendation that Australia should ratify the convention, but it is also not a complete coincidence that some of actually many of our recommendations align with ultimately what that convention has recommended. In particular, they had done some really good work, really considering the scope of workplace and worker. And we identified in our inquiry that Australia's laws hadn't really kept up with the evolution of the nature of work. So we were informed by that. Recommendations around the positive duty on employers rather than the complaints-based system, which we adopted or that we recommended. And also we were pleased with their recognition of the different drivers, power imbalances, but also gender inequality and the different drivers that affect, particularly for women and vulnerable workers. So our recommendations have turned into real life changes since that time, and I really welcome what has happened in the previous government and in this government. In particular, the legal changes over the last couple of years have comprehensively drawn the laws that we have towards a much more aligned approach where the safety, workplace and human rights agencies are all prohibiting sexual harassment, a broader definition of worker, a more comprehensive understanding of workplace, the Respect at Work Council bringing together those regulators with unions, workers and community organisations and employers, the Respect at Work.gov.au website, providing comprehensive information and guidance in one place in a free, easy to use location. And I've heard you previously have referenced our survey as well. But just as a last comment, I would say that at the time that I met with Ms. Tomei in 2018, she had talked about the importance of Australia supporting the adoption and also the ratification. What she had heard from some people representing Australia was the suggestion that we were already following the spirit of the convention and that there was really no need for us to ratify because we were already compliant. As you will know from our national inquiry, our sense was there was a number of improvements that need to be done. So I won't make a comment about whether we were complying, but what I do recall her saying very strongly is it was exactly because of that reason that Australia needed or really were an incredibly important country to ratify, because how could they convince other countries that needed to move forward when a leading country wasn't considering or wouldn't ratify? Now, there was no suggestion at that point we wouldn't, but she was just really clear that the countries that hopefully are in a leadership position are really important in the ratification process. So those are just some reflections for the committee and some background.
Thank you. That's very helpful. I've got a few things that I'd love you to respond to, and I'll then give other members of the committee the opportunity to do the same. First, there are two things that I understand have been identified as just sort of systemic shortcomings in the past that it seems we've begun to address, but probably have more work to do on. And so one is data, and the other is harmonisation across the Commonwealth and state and territory jurisdictions. So I just invite you to make some comments about those two areas.
Yes. Thank you, Chair. I think the question on data, so one of the 5 areas that we made recommendations on in Respect at Work was research and data. On one hand, we actually are globally leading. I know you've referenced the Australian Human Rights Commission survey. The Time for Respect survey in 2022 is in fact the 5th of such a survey, and they started in 2003. They have been used as a model. Even the United Nations has used the survey that we've done as a model in looking at workplace sexual harassment. So that survey is really leading. What we identified in the Respect at Work report was that there needed to be more detailed work done on particular groups. When you start looking at more vulnerable groups of workers, it is hard in a national survey to gather that more detailed research. So there has been funding given to ANROS, and there are a number of projects that are looking at specific cohorts, whether they're industries or, for example, I know there's a piece of work being done out of University of Sydney looking at retail workforces and particularly younger workers and their experience of sexual harassment. So I think that we can always do better. I know our latest survey, we really tried to get more granular. We're definitely getting industry data. I know you've been asking questions about the nature of the workers data, and we really did ask more detailed questions, but we did still find that full-time, casual and part-time was still the highest rates of sexual harassment, but that doesn't mean that we couldn't do better to reach other workers. And then, so I would say we're both, we actually are very leading and we need to use that data. I think that the latest survey, which was last year, showed 1 in 3 Australian workers had been harassed in the last 5 years. I am strongly of the view that all of the changes, the policy, the legal and the institutional changes have been made, and I think it is in the hands of workplaces to now be implementing those changes. We have the evidence. And so my expectation is the next survey, which will be in another 4 years, so 2026, we should see a reduction in sexual harassment. And if we haven't, well, I would say we should be doing interim reviews to understand, but I'm confident that we will see it provided workplaces do step up. So that's the comment on data. The other question, Chair, was
harmonisation, state, territory, and Commonwealth regulations in this space.
So this is, I would say this is the harder piece of work, personally. What the nature of the Respect at Work Council bringing together all of the regulators looking at workplace health and safety, workers' compensation, Fair Work and our workplace regulators and human rights agencies, plus the Workplace Gender Equality Agency, bringing together all of those on a federal, state and territory basis is a pretty phenomenal enterprise, and I'm chair of that group, so I know it's a phenomenal group, but I do know that that is the first time that that group has really come together in a uniform way to try and address a common problem by regular collaboration, clarity and consistency. In terms of how that is working, I think uniformly the members of that would say this has made a significant difference to how we work together. In terms of the laws, so one of our recommendations, I think 27, was that the state and territory discrimination laws should all be at least raised to be the minimum standard of the Sex Discrimination Act. It is the nature of a federation that takes a bit of time, and given that we're not just looking at those laws but also safety laws and workplace laws, I think the Fair Work Act is the only one that has such a comprehensive coverage. All the rest of us have state and territory mixed experiences. Having said that, I think we're in the best position we have been, and there is just some literal efforts to bring together so many departments, so many laws, so many regulators to be heading in the same direction. But again, I think the Respect at Work Council and the commitment to change, I know that we're making huge progress towards that, and I'm confident we can also achieve that.
Thank you. As part of this inquiry, the committee has been brought to consider the way that you can have, on the one hand, regulatory approach that creates the opportunity for harassment or violent conduct in the world of work to be reported and dealt with. But equally, that if you're serious about affecting change, you need to put effort into the preventative, norm changing, respect building part of the process. It is interesting that your Time for Respect survey says that nearly half of sexual harassment occurs in just 4 industry groups. So retail, trade, healthcare and social assistance, education and training, and accommodation and food services, those 4 groups. I assume that we would imagine the reason for that is that you've got precarious work is common in those areas. People, as you described before, casual or part-time work, you'd have a significantly higher presence of women in those areas, and perhaps even the use in some cases of temporary foreign labour. On the kind of preventative and norm changing and respect side, which you've done an enormous amount of work in that space recently. Do you feel that part of the sort of the future work in the spirit of the convention is sort of well underway? Are there particular things that you believe might need more attention in that kind of category in the short term?
I've got 2 reflections on that. My first reflection is those statistics on the highest industries, they are also the industries that employ the highest number of people. So that statistic that you're reading did not concern me in a sense, in that when you correlate it to the industries that employ the most people, it is not surprising that they have the highest actual quantity of sexual harassment. There is also some other analysis, though, that does grade industries by the industries that rank above that 33%, where the national average, which I think is appalling, is 1 in 3 Australian workers having experienced sexual harassment in the last 5 years. But so, for example, I know arts and recreation falls above that in around the 40%. I think mining does as well. And I make those comments because what I know is since 2018, when we first started reporting the industry data, and then when we produce Respect at Work, one of our key recommendations is that workplaces need to understand sexual harassment less as a matter of individual misconduct and more as something that's a systemic risk factor that exists in their industries. So one of our recommendations was encouraging comprehensive sort of industry responses. And so if I use your example, and do I think they're well advanced? I don't think they're well advanced, but I absolutely do see in so many industries a collective effort to understand, for example, if I use the arts and recreation, which includes sports, but if you use the arts, this new national cultural policy specifically includes a function that is to address and recognise the high rate of harassment. As a sector, it's highly sought after. There's predominantly still men in leadership positions, very insecure or temporary work. So there are a number of factors that mean that people are in less powerful positions and face great risks of sexual harassment. If you go to mining, remote work sites, male-dominated industries, so they're in each industry, or at certainly each of the higher risk industries, there are some really clearly defined factors about the way the work is done and the working environment and the demographics of the workforce. And so we recommended in Respect at Work to do what is actually pretty common practice now in the safety regime, and is also part of the convention, which is you look at these risk factors, you look at the nature of the work, you look at the demographics, and you understand what those risk factors are and mitigate them. And I do believe that that is something that certainly in the last 2 years, industries have really drawn together, and I can think of universities, legal sector, mining, construction, arts, media and entertainment, retail. So I can give you a long list of industries that have really started to approach this in a different way. And it gives me a lot of optimism, and we're seeing real change. Parliament is another one. If I use that as an industry, by understanding what the nature of work is and who is working there, you can understand what the risk factors are and mitigate them.
Okay, one more question from me, and then I'll see if other committee members would like to put something to you. And it just goes to the your understanding of the convention as a sort of a dynamic collective effort, something that Australia will continue to sort of work on or work in the spirit of, but also presumably report back through. I can't remember seeing through the papers that were produced whether there is a sort of a national reporting obligation, but you've talked about the fact that the next Time for Respect survey, that 5-year period, will conclude in 2026. That will be a piece of our own internal data alongside the stuff we get through the ABS. Is it your understanding that we report to, as part of our, if ratification of the convention occurs, that we'll have a reporting obligation that might pick up some of that internal data and therefore tell us about the progress that we obviously need to make?
I'm more familiar with the United Nations conventions, and I know that there is generally a reporting cycle for those. So off the top of my head, I would expect that Australia will be reporting back, will continue to learn, and I'm confident, given the work that has been done and the new functions, including the positive duty at the Human Rights Commission, that Australia will have a really rich and valuable source of information. It will be a process that is a valuable process for the country to keep moving forward. So you can probably tell I'm really supportive of these voluntary and positive ratifications. And then it's really, as a country, for us to then hold ourselves to the standard. And I do agree that we have learnt a lot in the last 5 years, and I think as we move forward, we will continue to learn. But as a country, we are so committed and really forward leaning on our workplace benefits and entitlements that I think that report back process will really be a valuable exercise. Can I tell you exactly what the reporting back cycle will be? Not right now, although I am shortly to return to Geneva as part of finishing the role, and I am meeting with the Assistant Director General, so I can ask her directly how that will work, but I'm sure the Attorney General's Department and the Department of Workplace Relations can give you the exact specific answer to that, Chair.
Thank you. Look, I'm sure we can get that through the departmental folk too. I probably ought to know it. Just one other thing. I mean, as someone who's undertaken and led a lot of the significant work we've done, to what extent, and we've been told too that our ratification, I mean, it's an interesting thing, I think, for Australia when it comes to ratifying international agreements, because you can see it both ways. Some say, what's the hurry to ratify when we're already compliant? And another view would be, well, if you're already compliant, why would you hesitate? It has been indicated to us that participation in this agreement, even at the signing end, from countries in our region isn't very good. That I think it's only Fiji, and that it's difficult for us to be a role model and an advocate when we ourselves haven't ratified, and this will help. But do you have any sense of the way in which some of the steps that have been taken in quite recent times, responding to recommendations in the report that you led, like the introduction of domestic violence leave, the legislation that puts that sort of thing in place? Have you had any experience of how that is received outside Australia? How other countries look at those kinds of steps in terms of what they might consider?
I have had experience. It's been one of the great privileges of the role. The last couple of years have been all remote, but my personal strong belief is that Australia is incredibly highly regarded in particularly work on gender equality internationally. And I think at home we don't always realise this. We have some really remarkable roles on gender equality, if I just start there, which would include the E-Safety Commissioner, the Workplace Gender Equality Agency, the Ambassador for Women in STEM, we've got an Ambassador for Gender Equality, and there are more, a really amazing network of remarkable people, but also institutional commitment to not being complacent and moving forward. I think that really hit me in that conversation in 2018, where the ILO said, actually, we can't make this a better world if countries that, might be the leaders won't engage in this international norm setting process. I think Australia is leading. I think that us ratifying this, as we do so many international things, is done both because we think we're doing well, but we also think we can learn. And I would hate to think that we would ratify this in an arrogant confidence that we were all over this, because we know that we also have challenges with violence and harassment in workplaces, and we're trying to be better. I guess my support for the ratification is that I'm confident that when we ratify things, we say they're important, and as a country, it will keep our focus on the issues. We've made such progress over the last 5 years. It's even, I guess, surprised me. But the momentum is just getting going, and I think we're going to see some real change. But I still think there are things to learn, and our national inquiry learnt from the ILO's work. And I think I think both it's important for our regional leadership, but I also think it's an important way for us to continue to get better, which is something that I think Australia really should be welcoming and embracing.
Thank you. I'm not aware that other committee members want to put questions to you. This is their last opportunity, but in any case, that's I think a nice and substantial note on which to end the evidence that we've received on this convention. So, Commissioner Jenkins, I'll just thank you for your attendance here today. Your submission, obviously. Hang on, I'm getting no. For the work that you've done in your role, your report, the submission and the evidence today. Now, we haven't asked you to provide any additional information. We'll go and check the reporting obligations within the convention directly with the department. You will be sent a copy of the transcript of the evidence that you've given today when it becomes available, and have an opportunity to request corrections to transcription errors. But again, thanks for your time and your work.
Thank you, Chair.
Okay, committee members, I therefore declare this public hearing of the J. Scott closed.